Dear colleagues, now it is my turn to watch the clock ticking. In the next 15 minutes, I would like to speak about the protection of children's rights in the inter-American system of human rights. The need to protect children in Americas has been a long-standing concern because of the high rates of violence, especially among young people, child poverty, and economic and social inequalities in that region, particularly those affecting indigenous children. These have justified increased efforts to protect children and adolescents in the Americas, and they have led to enshrining of children's rights in the major human rights instruments within the inter-American system. So what is the inter-American system of human rights? It was formed under the auspices of the Organization of American States, which is a regional international organization established in 1948 and currently composed of 35 countries on both American continents, including the USA and Canada. The main human rights instruments adopted in the inter-American system are the American Declaration of Human Rights and Duties, adopted in 1948, a few months before the UN Declaration of Human Rights. It is a non-binding document. And the other one is the American Convention on Human Rights, adopted in 1969, and later supplemented by 2 additional protocols. It is a binding international instrument, and not all the member states of the OAS are state parties to the convention. However, all of them have signed the American Declaration on Human Rights and Duties, and it is an important difference which has far-reaching consequences for the enforcement mechanism. So these 2 documents, the 2 pillars, the American Declaration of Human Rights and Duties and the American Convention on Human Rights, provide for the most important normative framework for protecting children's rights in the Americas. Article 7 of the American Declaration states that all women during pregnancy and breastfeeding and all children have the right to special protection, care, and assistance. And Article 19 of the American Convention on Human Rights states that every minor child has the right to the measures of protection required by his condition as a minor on the part of his family, society, and the state. The implementation of human rights by the OAS member states is subject to the control and monitoring by 2 bodies, the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights. The Commission, which is based in Washington, D.C., has the competence to monitor the overall situation of human rights in the Organization of American States, including examining individual complaints about human rights violations against all member states of the Organization of American States. The decisions adopted by the Commission, however, are not binding on the states parties. The Inter-American Court of Human Rights, which is based in San Jose in Costa Rica, has also the competence to hear complaints about violations of human rights enshrined in the American Convention on Human Rights, but its decisions are binding on states. It also has non-contentious competence to give advisory opinion. The complaint concerning alleged human rights violations can be filed to the court only via the Commission and only against a state that has ratified the American Convention and adopted the jurisdiction of the court. And that narrows down the jurisdiction of the Inter-American Court to 23 member states out of 35 member states of the Organization of American States. So in the next couple of minutes, I will focus on the court, who is the ultimate arbiter of human rights in the Americas. The first judgment in which the court ruled on children's rights, based on Article 19 of the American Convention, was the case Villagran-Morales versus Guatemala, which is better known as the case Street Children versus Guatemala. It was delivered in 2003. This complaint was filed by the parents and relatives of 5 teenagers who were kidnapped, tortured, and murdered by police officers in the capital city of Guatemala in unclear circumstances. The police officers had been subsequently acquitted by the Guatemalan courts, and throughout the entire time, the state authorities denied the families and relatives of the children any information about the events and circumstances of the children's death. The teenagers, the victims, were so-called street children, so children in a situation of social exclusion, growing up on the streets of large cities, often homeless. It is estimated that this problem affects even 50 million children in Latin America, of course, not only in Latin America. So this case, the case Street Children versus Guatemala, concerned typical systemic problem and egregious violation of children's rights in Americas. In that case, the court found that Guatemala had committed a serious breach of the fundamental rights guaranteed under both the American Convention on Human Rights and the Inter-American Convention for the Prevention of Torture. Guatemala had not adopted special measures to protect the disadvantaged children and had instead tolerated their arbitrary arrest, torture, and murder as part of a broader pattern of violence against street children and disadvantaged children. By denying the families information about the events, the government deprived them of legal protection, which amounted to cruel, inhuman, or degrading treatment. In this very first case on children's rights, the Inter-American Court set out the main principles, which then were elaborated in the subsequent years, in subsequent decisions of the court, which has led to the formation of a clear line of jurisprudence of the court in cases concerning the protection of children's rights. Its main elements are the following. First of all, the principle of an integral approach to the protection of children's rights. According to the court, the scope of the right to special protection, stemming from Article 19 of the American Convention, and the corresponding obligations of the states should be interpreted in light of the provisions of the UN Convention on the Rights of the Child. Second, children's international legal personality. According to the court, children are genuine right holders and subjects of international human rights law, and they can assert their rights before an international court, regardless of their social or economic position. Of course, it is a clear echo of the approach adopted by the UN Convention on the Rights of the Child. The third element, the principle of special protection. Article 19 of the American Convention provides children with additional protection vis-à-vis that afforded to all other persons under the American Convention on Human Rights. This subsidiary additional protection corresponds to the special obligation of the states to adopt specific measures of protection for children. These specific measures of protection should be determined individually based on the particular circumstances and the personal condition of every child. It means that children in different situations of vulnerability require different protective measures. And as we can see from the case law of the Inter-American Court, for example, children at risk, such as street children, need special measures of protection that ensure their survival and full development and provide minimum conditions for a dignified life. Girls and young women require special protection from sexual violence, both in educational institutions and within the family environment. Protective measures for indigenous children should focus on respecting their distinct cultural identity. Special protection for migrant children requires culturally appropriate and gender-sensitive measures to ensure access to healthcare, education, adequate conditions for development, and legal and medical assistance. For child deprived of liberty, special protection requires that such children are treated separately from adults and provided with regular healthcare, access to education, and living conditions that allow for normal growth and development. And finally, the principle of the superior interest of the child. The best interest of the child in the court's case law is an overriding principle which should be taken into account in all judicial and non-judicial proceedings affecting children. Again, a clear echo of the 1989 Children's Rights Convention. Finally, also let me mention one advisory opinion of the court. In 2002, the court issued an advisory opinion on the legal status of children and the rights of the child. It was delivered in relation to the practice common in Latin American states that the decision concerning children in criminal, civil, and administrative proceedings are taken based on social position, economic situation of the children's family as a factor determining the type of protective measures. In this opinion, the court expressed its strong support for the children's right to participate in the proceedings affecting them. The court also emphasized that the right to fair trial should be fully exercised in all proceedings affecting children, judicial and non-judicial proceedings as well. And the court recognized that the protection measures adopted by the state authorities should be in full accordance with the law and should aim to support the child's relationship with his or her family. According to the court, public authorities should prevent the separation of the child from the family because it is the family who plays the primary role in child protection. So to summarize shortly, the Inter-American Court of Human Rights, together with the Inter-American Commission on Human Rights, are carrying out a truly grassroots work in the field of human rights, including, of course, the rights of children and young people. Their task is to oversee the implementation of human rights in Americas, but also to raise awareness and to put an end to the climate of impunity that often accompanies human rights violations committed by public authorities, unfortunately often to the detriment of children. In my two contributions, in my two written contributions in that book, I analyzed the case law and the approach of both organs in more details. So I invite you to take a look at these contributions. For me, particularly, one of the most interesting part of that research was the research on the case law of the Inter-American Commission on Human Rights in relation to the United States. Because, as we have already heard today a couple of times, the United States is the country that has not ratified the UN Convention on the Rights of the Child. As such, it is not, let's say, accountable for violations of children's rights guaranteed in that instrument. However, as a member state of the Organization of American States, it has signed the American Declaration. And the American Declaration Human Rights and Duties, which, as I mentioned at the beginning, provides also for the rights of the child. So based on that document, based on that provision of Article 7, the United States can be, to some extent, holds into accountability in front of the Inter-American Commission on Human Rights. And the case law of the Inter-American Commission concerning the United States is also a part of my written contribution. Thank you very much for your attention.